by A&M Global Law Firm. A&M Global provides legal services across the globe. A&M has also been awarded Who is Who Law Firm of India in 2019. A&M Global is based in Mumbai, Delhi, and Bangalore. I am Sukhaminder Singh Aluwalia, Delhi-based partner looking after litigation, dispute resolution, and arbitration practice of the firm. Today's topic of webinar, Enforceability of International Investment Arbitration Award in India and Relevance of ICSID, is based on investment disputes arising out of bilateral investment treaties. In order to resolve such disputes, India, being member of New York Convention and Geneva Convention, adopts the UNCITRAL model. The Arbitration and Conciliation Act 1996, as amended up to date, is completely in the line of UNCITRAL regulations. Because of that, India also enjoys state immunity. So every international arbitration award to be enforced in India has to satisfy the conditions set out under Section 48 of the Arbitration and Conciliation Act 1996. Very recently, the Honorable Supreme Court of India, in the case of NAFIT versus Elmenta SA, was pleased to set aside the International Investment Arbitration Award on the ground of public policy. So to a certain extent, this also discouraged the investors for further investments in India. Does that mean that Government of India needs to revisit the process of enforcing international award? And can we say that International Center of Settlement Disputes, ICSID, is relevant option for India in order to attract more investments? So for that discussion, we have our esteemed panelists, Mr. Suri, Professor Dr. James, and Mr. Sandeep Patel. Mr. Rupinder Singh Suri, Senior Advocate, Additional Solicitor General of India. Mr. Suri is National Representative of India of the UIA, which is International Lawyers Association, and ex-President of Supreme Court of India. He has defended several multi-million dollar arbitrations on behalf of prestigious public sector undertakings, and also he is the member of Arbitrator Board of Delhi International Arbitration Center. And of course, he's also considered one of the leaders in domestic and international arbitration, especially on the commercial dispute. We welcome you, sir. Professor Dr. James is a professor of Jindal Global Law School and head of CTIL. Professor James is also part of the Ministry of Commerce and Industry at the Indian Institute of Foreign Trade. Professor James received his PhD from National Law School of India, University Bangalore, and holds graduate degree in law from Cambridge, UK, New York University School of Law, USA, National University Singapore. He has appeared in various WTO disputes proceeding as part of the Indian delegation, including Indian agriculture products in India, export subsidies, as well as various dispute consultation proceedings. We welcome you, Dr. Professor James.
Thank you.
Mr. Sandeep Patel, Queen's Counsel, fellow member of Chartered Institute of Arbitration, managing partner of an international law firm, Alliant. Mr. Sandeep appears in domestic and international commercial disputes concerning fraud, finance, goods and services, energy, national resources, and construction. He appears in international arbitration conducted under rules of various institutions such as ICSID, ICC, HKIAC, LCIA, and ad hoc proceedings under UNCITRAL rules within civil law and common law jurisdiction. He appeared recently in the reported international arbitration case on the enforcement in England New York Convention Award. We welcome you, sir, and we thank you all of you to start this discussion. I would request Mr. Suri to put some light at what are the conditions of the enforcement of the International Investment Arbitration Award, because in India, when we have to enforce the Investment International Arbitration Award, there are some conditions which have been stated under Section 48 and also otherwise in various settled laws. So can you put some light on it?
Sukhminder, thanks for a lovely and elaborate introduction of mine, which is not so deserving. Today we have a panel where you have one student, that is namely me, and two masters, namely Mr. Sandeep Patel and Professor Nedupara. Long and short of the Indian arbitration history, which I'll just take a minute before coming to the main topic, is that since 1999 we are having arbitration. 1899, more than almost a century more arbitration. Then from there we come to 1940 Arbitration Act, And then thereafter, we come to the present 1996 Act, which has been amended in 2015 and then recently also. We had not many court interventions, in spite of the fact that people had chosen arbitration so that it is outside the court course. But courts came into that. And while we were on course over a period of time, we got derailed with the saw pipes judgment, where again the option to challenge had increased. But the final word as of today is Sanjong judgment. And I slightly differ with you. The Neffert judgment is not dilution of that judgment. It is interpretation of the Supreme Court that the law prohibited carrying over of material to be supplied, groundnut material to be supplied in the next year, which was not permitted by the law. So public policy now means it should not be against any Indian law or any other regulatory situation. So law still holds and a very strong judgment in Sanjong judgment, which says that no, the interference in the arbitration should be minimal. Now coming to today's topic, the exit, we are not a signatory to the Washington Convention. We have not agreed for any arbitration execution in India under this particular procedure. But under our constitution, we are bound to honor the international treaties. But those international treaties require to be translated into municipal law. And so far, we have not translated it into municipal law. So therefore, if you have a ward under ICSID, the issue that arises is how would you implement it in India? The model that we have, as very rightly summarized by you, is unilateral model. Now, under that, we are a signatory to that New York Convention, and it can be executed in India. We also have our Civil Procedure Code, which recognizes the international decrees. And it honors it that you file here and you can be executed except on the grounds that are prohibited. But then award is not a decree as per the definition of judgment. So neither unilateral model is available to you, nor the Civil Procedure Code is available to you. How would you implement and execute exit is a big question mark. Two courts in three cases have applied their mind on this issue. One is Calcutta High Court, which says no, the Arbitration and Conciliation Act 1996 should be applicable. They also issued anti-arbitration injunction against Calcutta Port Trust. But Delhi High Court in two judgments, Vodafone and Khaitan, has categorically said that 1996 Act is not applicable, but they have made it very clear, both the judgments, that no interference by the court should be minimum, and they have rejected the plea and the request of the government of India to grant an anti-arbitration injunction. And there the thing rests, because the final verdict, they have to go through the total gamut of the High Court procedures and all that, and then come to the Supreme Court, and then some analysis will come. Question now that arises is that can India wait for a decade to come to a conclusion whether it has to be executed or not? And answer is not, because India today is following the Atmanirbhar policy, that is self-reliant policy. You are self-reliant to become a manufacturer hub in India for exports to the world at large. Now you must see it in the background that India today is one of the 10 and top recipient of FDI. And India is one of the 20 for the outbound FDI. So both incoming and outgoing is very vital for India. If in India exit does not suit them, outside it may suit them because they are investing abroad also. India signed almost 83 bilateral treaties based upon the London Treaty, which later on proved to be totally investor friendly. And then they were shocked by the decision in White Industries case. And it's not only that 4.8 million Australian dollars compensation was levied on them. It was also a very stringing stricture on the court procedures in India because almost about 8 years had taken place and no headway had been taken. Now that's the beauty about exit because exit is between the governments, which can be invoked by one of the investors there. In that, it is very interesting to note that can it be? That's a question. Can it be that even court's action can be challenged in the exit? Now, when you are dealing with a sovereign to sovereign, our judiciary is nothing but a part of the sovereignty. And therefore, under the exit, even the decision by the court can also be challenged. This is a new dimension. There's nothing there, but that's what I read by reading it. Now, if that is going to be the situation, it has been slightly been discussed in the Khatan's case on this issue, the honorable judge has discussed it. Of course, honorable judge has come to the ultimate conclusion that no, they were Supreme Court was only criticizing the executive action, first come, first served basis, and therefore it is not the decision of Supreme Court which has been criticized, but the action of the executive which has been under challenge. Now, after we suffered this, there is a shock, almost a paralysis on the Indian side, and they cancelled almost 58 bilateral investment treaties. And then they have drafted in 2015-16 a model bit of treaty, which is now the base on which the other treaties are going to take place, and it is to be discussed in future with negotiating any other treaty. There they have tried to fulfill the gaping holes which were there. And in this, uh, uh, the issues that have arisen is that there is a scathing criticism of ICSID in the sense that there is no appeal provision, and frankly, it should not be there. It can only be annulled, but bias towards the investor, that is a very legitimate complaint. Second is the high cost, and there is need to balance the interest of not only foreign investor but also of domestic policy, regulatory authority, and sovereignty of the host country. Long and short is that if you want to negotiate on one-to-one basis, you must keep all these four things in mind and then negotiate. I personally think that India cannot afford to lose the opportunity of becoming the member of ICSID. It must take all the precautions that are in the national interest, but it must become its member at the earliest, and after taking all the precautions and protecting their own interests. And therefore, according to me, it has to uh, create an ecosystem for execution of exit awards. Otherwise, it will be no good. And therefore, assurance to the investor should be there of swift, competent, reliable award and its execution so that business can be done. It would be a necessary input for India becoming Atmanirbhar. That's in long and short is my suggestion.
Sir, I have just one small question, sir. That
Yeah,
under section 48, subsection 2B, which talks clearly that enforcement of award cannot be acted upon if it is against the public policy. Now, if we are joining ICSID, of course, it is in favor of the investor. There's no doubt because the results of the ICSID arbitration can be left or right. But don't you think that India will lose the state immunity, the what you call the predominance of the Indian judicial system on the international awards? Then that means that India is simply allowing whatever is permissible in the country, which is being passed across the border.
So, Bhinder, that's exactly what I'm saying. India will negotiate. After all, what would execute in the award? It would do it whatever the arbitration clause is. And in your arbitration clause, you would have taken care of your public policy. You would have taken care of the of the investor bias, and you would have taken into account the domestic policy. All those things would be there, and ICSID would take that into account. But whatever award they will pass, India would be bound to implement it, and only challenge it only for annulment and for nothing else, only for absolutely absurd reasoning if it is there. So, Exceed is going to be implemented in its true spirit and all that, but it is sovereign to sovereign. But for that, ecosystem would have to be created in India for its execution. So
Uh,
2015 is a different ball game than the 83-bit um, uh, treaties that were there on the based upon their first bit treaty with the London. But now they are taking into that account, and they must now move forward if they have taken into that account. I would absolutely say it is necessary for India to become part of EXIT, but they have to take proper precautions and then go in it wholeheartedly if they don't want to miss the opportunity. India is in the go and it will do very well, but it has to give that assurance to the international investors that your interests are going to look forward. And I am looking for a time when India becomes the hub of the international arbitration center, in addition to or even better than London, Paris, or Singapore.
Wonderful, sir. Thank you very much for your views. Professor James, taking here forward, India signed bilateral investment treaty with UK in 1994, and then between 2004 to 2011, there were almost 80 bilateral investment treaties. But the last one was in 2004, which wasn't signed, and till 2020, there was only one bilateral investment treaty that was with Brazil. So now the point is that does that mean we are losing the actual flavor of foreign investments because of our hard thrust judicial system on the investors?
Okay. So thank you, Sukrinder, for this opportunity. And thank you for being part of this excellent panel. Let me actually, before answering your question, let me touch upon the question that you put to, senior advocate, Mr. Suri. The point is that the ICSID is only a forum. It is only a platform to try or resolve a particular dispute. The underlying subject matter is basically the BIT. So whenever a country negotiates a BIT, it will have to make sure that the BIT contains a public policy exception. So if you look at India's model BIT, there is a specific category of public policy exemptions, sometimes for public morality, sometimes for public order, sometimes for public health, sometimes for the protection of environment, or maybe for other conservation of natural resources. And we also have security exceptions. So generally speaking, almost all modern BATs actually contain a category of exceptions called non-precluded measures, because every state actually wants to pursue certain kind of legitimate public policy objectives which fall within the police power of the state. The issue is that if a country has signed a very bad BAT, then the outcome that you get from any tribunal won't be very different. So in that situation, the ICSID tribunal, to my understanding and from my own research, comes out as a very strong tribunal. We should admit the fact that in the 1970s, in the late 1970s, the first dispute to have actually come up before the ICSID tribunal was the Moroccan dispute in 1972. But even our own neighbor Sri Lanka had a dispute with Hong Kong way back in 1989. So many developing countries had been part of the ICSID system. And one criticism at that time was that ICSID is actually part of a new Washington consensus model, which basically believed in neoliberalism, opening up the borders, making the borders and the policies much more investment friendly, and thereby taking away the policy space of the state. But in the last few years, I mean, let me actually touch upon that point before answering a question. Let me touch upon a bit of history about ICSID as well. In the last maybe 10 or 15 years, there has been a strong backlash by some of the Latin American countries against ICSID. The three Latin American states of Ecuador, Venezuela, and Colombia, they actually came out of the convention. At the same time, some other countries actually joined the convention, like Mexico. So the point here is that sometimes these countries suffered because of their own very bad policies, especially Argentina. That country took a large number of measures. As anyone knows, that country took a large number of measures in the 1990s, basically in the field of utility sector. And these measures were actually taken for stabilizing their macroeconomic policies. But what happened is that when you do a kind of a policy, if you do not follow the principles of natural justice, if you revoke a license without giving a hearing opportunity, or if the investor basically feels that his or her investment has actually gone completely sour or lost, then of course I think the tribunals will take a hardline position. So even if the disputes goes to an ancestral tribunal or maybe SEC tribunal or even London or Singapore, international tribunals, I think that the outcome will not be very different. So the point here is that, let me actually come back to the issue. India was interested in the negotiation way back in the 1960s. But what happened was that India, as you rightly pointed out, wanted to have certain kind of policy flexibility. So that is why you refer to, even Article 48. On some of the public policy grounds, a foreign arbitral award can be refused to be enforced. But here again, I think, in this particular discussion, we should be completely cognizant of the void. The void here is that, so technically speaking, we can argue that the 1996 Act will also apply to the enforcement of an investment arbitral award. If it doesn't apply, then what will regulate the sector? Let me also give, narrate an experience from my own familiarity with the WTO legal system. In the WTO, there are a large number of public international disputes, and these disputes are actually called panel reports, adopted panel reports, or appellate body reports. They don't actually called awards, so they may not be, in a way, they need not actually qualify the definition of a foreign award under Section 44 or even under Section 9 of the CPC. But the government of India, in most of the cases, will actually comply with the award, because what will happen if the government doesn't comply? The other state will take a retaliatory action. So in the field of public international law, based upon the principles of comity, every nation will try to comply with an order passed by an international tribunal. But I at the same time, I acknowledge that if a foreign tribunal has given an award completely contrary to the public policy of the enforcing state, then the domestic courts should have certain amount of flexibility, very narrow amount of flexibility. And I do not know whether opening up a foreign award based upon merit is actually a good thing. The flexibility should be very carefully exercised. And I think this principle has been mentioned even when I read the NAFID judgment. The Supreme Court has actually referred to various judgments. Even the Renu Sagar decision, they have actually referred to some of these decisions, in fact. But the point here is that, there is a global competition for capital. India badly requires capital. And the reality is that capital is extremely mobile. Capital can go to any country. And the people who invest in a country are not really worried about, whether your country is actually very interested in enforcing public policy objectives. When an assurance is given to an investor and when the investor has made an investment in the country, I think that investor would like his or her investment to be protected. So sometimes, when we actually come even to the White Industries case, some people actually argued that the mistake was with the executive. Some people argue that the mistake was actually with the judicial system. Maybe the judicial system, the judiciary looked upon the matter only because the executive messed it up. So it is very difficult to put an accusing finger on anybody. What I can say is that as a state, as a responsible state, I think all the organs of the state will have to work in tandem. And sometimes, based on public policy objectives, a court can actually intervene with the award, but that should be on a very, very narrow ground. And if the court start interfering in some of the foreign arbitral awards, it can actually create a very unpleasant situation. So now, while coming back to the ICSID tribunal, I think I tend to agree with that. The ICSID tribunal is actually appearing to be the best tribunal among all the contemporaries. There is an accusation that an ICSID arbitral award is a final award. It will have to be deemed as a final award or decree of the highest court in the country, and therefore straightly enforceable. Let me tell you, there are some parallel developments happening in the working group 3 under the UNCITRAL. So that working group is basically seized of the issue whether there should be an appeal mechanism even with respect to ICSID. And my feeling is that in the field of international investment treaty arbitration, the most serious challenge or the most serious criticism is that it doesn't have an institutional setup. So ICSID by far is actually the only institutional setup that we have. But India is not a signatory to it. Maybe under the additional facility rule, some of the disputes involving India can be adjudicated under the tribunal. But my own feeling is that the World Bank has actually undergone a substantial and serious change in the last 40, 50 years. The World Bank is no more considered to be a messenger of the neoliberal policies. Of course, in the 1970s and 80s, when Western countries or developed countries made capital investment in other countries, they wanted security for their capital. So to an extent, the World Bank or the IMF policy actually represented the Western capitalist orientation. That I agree with that. But if you look at the recent trends, even the internal reforms they have undertaken, my own feeling is that they have actually become much more friendly, and they have become really cognizant and aware of the problems suffered by the poor countries. But on the other hand, now we can look at UNCITRAL, we can look at the Stockholm Chamber, we can look at any tribunal for that matter. I can tell you very clearly that the amount of respondent state losses in these forums is actually higher than the losses under the ICSID. So, when we make an objective and a calibrated analysis, it is absolutely clear that ICSID has become absolutely the most respectable and to an extent a reliable international tribunal. ICSID being part of the World Bank should not be a disadvantage. It can be an advantage, because World Bank is involved in even in many developing countries in a number of developmental activities. So, I think the long position that India has taken with respect to ICSID, in my opinion, should be relooked. And the second point with respect to the policies, the policy flexibility which you mentioned, to an extent, I think I tend to agree with you that every country should have certain amount of limited policy flexibility to review a foreign award, a very limited policy flexibility. And the second issue is that my own feeling is that there is no provision under the existing laws in India dealing with a foreign investment arbitral award. So there is a vacuum over there. That vacuum can only be plugged through some kind of a lawmaking, right? So that is again an issue. I mean, even if we give a fairly broader interpretation that investment treaty awards can have the nature of a commercial award under Section 44, I do not think that we can actually equate an international treaty award with a commercial award. So there are certain issues involved over there, and I think it is high time that we resolve these issues, because India is a major respondent in investor-state disputes. We have got around 15 to 20 cases where we are a respondent party. So these are just some of my opening remarks. Maybe if you've got further questions, I'll be happy to answer it.
Thank you very much, sir. Mr. Patel, now you see there is one a kind of impression in the foreign investor that Indian judicial system doesn't support the investment process. The white industries case is one of the classic examples where arbitrators have shown their dismay that why the process took 9 to 10 years. Even in the NAFID case, after the 9 years of the entire process, the award was set aside. Of course, then we can say that it's not a rumor. Of course, there is a situation where investor has a feeling of insecurity when he wants to invest in India. But that is through bilateral investment treaty where both the governments have to take care of each other interests. Now, from that point of view, you are the person sitting in England. From the international point of view, uh, what is the you are of course a foreign lawyer but from the Indian origin, so you also understand the Indian culture, the feelings of Indians, how they're attached to their country, their assets. So is it really very relevant for us to ignore the unsettled regulations and simply jump into and join the exit at this stage? Because the provisions, the points which India enjoy under the unsettled model, that India will not be able to have. And even though we are going to get a lot of investments by joining exit, but does that mean that can be on the cost of our own principles and the policies which we regulate across the globe?
Uh, the simple answer, I think, to that, and I'm grateful to the previous panelists because I echo a lot of what they have said, if not all. The general perception outside of India, within the investor community, is that India is a hard place to do business. It's a difficult place to do business because if there is a dispute which occurs, then it is going to be it's going to be costly and time consuming to resolve that dispute, including international arbitration. And that's a perception which I think we all are aware of. And I think it's a genuine worry, it's concern. I don't think, my personal view is that it is almost inevitable that India will have to become a party to ICSID if it wishes to fulfill its economic ambitions in the long term. I see no other way, because there is no other institution which can deal with these types of disputes in the way that it can, as the good professor has just mentioned. I don't think, in my view, it'll be a disadvantage to India to become a party to ICSID for two reasons. One, because it will be able to fulfill its economic ambitions. It'll be good for the business community and the environment. I don't agree that if India becomes a party ICSID, then it will suddenly lose the benefits of the UNCITRAL model, because the United Kingdom combines both in this country. And so I just remind myself of what the situation is here so far as bilateral investment treaties are concerned. And so far as the United Kingdom is concerned, it has the largest number of bits in the world. It's 90 at the moment. And it has the greatest number of bilateral, multilateral agreements, in excess of 14,000 treaties. Of course, we are leaving the European Union, so that's going to cause a knock-on effect. But those figures, when I looked at them, researched them, I thought were resounding, because it's what business community wants. It wants the reassurance, the certainty that there will be a bilateral investment treaty which will be enforceable either in a court of law, by the ICSID, or under UNCITRAL, and so forth. Now, another fact which I can share with you is that in relation to any investment treaty awards, at the moment, there are no publicly known investment treaty awards rendered against the United Kingdom. And that applies also in relation to ICSID cases. So there are no known investment treaty awards rendered against the United Kingdom. I wanted to make myself aware of those facts because in your very good article, and just mentioned by the professor, at the moment there are around 20 international investment disputes pending against India, which is, and when I looked to see what the law was insofar as the United Kingdom, which obviously I know, there was a recent case in the Supreme Court, which was an ICSID case. And it had no hesitation in implying the 1996 Act, which applies in this jurisdiction, that the award was to be automatically registered, it being a competent and enforceable award. And even though the parties had argued various aspects of public policy and so forth, ultimately the Supreme Court stated that a strict interpretation of the legislation here meant that the award would be automatically registerable and therefore enforceable. And so there is very limited scope for the non-registration of an ICSID award in the United Kingdom, limited to public policy, but public policy is not the same in the United Kingdom as it is in India. And so the judiciary views public policy in very, very limited circumstances. It's almost non-existent, usually to do with illegality, but even in circumstances where the underlying agreement was illegal in the initial country, the law here will still apply that award. So what does that mean? Well, we all hear that the description arbitration friendly, and the United Kingdom is arbitration friendly because of the New York Convention. But there is no doubt in my mind that membership of ICSID benefits the business community in the United Kingdom and generally, because as we all know, ICSID by its own way has the equivalent of the New York Convention on Enforcement of Judgments. If you're a party to it, you can have an award recognized in any country which is a signatory to it. And so my view is that India can overcome whatever difficulties it has in relation to how it views public policy. And I think that's one of the fundamental problems. And as we all know, that I think it was Lord Denning who resurrected the phrase that public policy is a very unruly horse, and when you get astride, you never know where it will carry you. And so far as arbitration is concerned, international arbitration, ICSID is concerned, the judiciary are very alive to the fact that public policy is not a horse which should be ridden frequently, if at all, but to apply the principles behind the UNCITRAL rules and also the 1996 Act, which we have as in the United Kingdom.
So I have a question here. See,
Please.
When we talk about ICSID, it is the body established by the World Bank, and World Bank means, of course, ICSID only relates to the investment international arbitration.
Yes.
And no arbitration. Now, from that point of view, don't you think it appears to be that it is a pro-investor body, which will definitely damage the developing nations to a certain extent? Because the regulations of ICSID under Article 52 of ICSID regulation, it's very strict for the enforcement of the Investment International Award. And there is no doubt that once the award is passed, then it has to be enforced. Annulment is it might be in one or two cases, but not in every case. So where we talk about the thousands of crores of investments coming into a particular state, and then there is a possibility that dispute may arise in any situation. From that point of view, isn't it a threat to the country to a certain extent that that state may feel insecure, that simply because of seeking the more investments, the ICSID is of course one of the platforms, but when it comes for the decision of such claims, it is not good for that state at all?
It's probably more so a political question or a concern, I think, because using the United Kingdom experience, the United Kingdom and the government has no difficulty in enforcing ICSID decisions, wherever they may be, and if it be against the state, then so be it. That is that's the law, and there is very little scope for moving out of that, so that there's very little discretion, if at all. There is always a concern, but I think this is a political concern at the end of the day, should there be more discretion within the domestic legislation as to the judiciary to be able to decide not to enforce, and let's use ICSID as an example, ICSID award. It goes back to what is the overriding objective of becoming a party to ICSID? What is it? And I think it is, if it is to benefit the business community and the business environment, and also therefore to provide commercial certainty to partners, then in my experience with my clients that I meet and discuss these matters, what they want is just certainty. They don't want to be put in a position where they say, well, all right, look, we will take this course, but if we have to litigate this in India, for example, or let's say, is this investment award going to be enforced in India? And if so, what's the certainty of it? And that's what the business community wants, simply to be told, reassured that there is a high level of confidence in the system in whichever country they're contracting or litigating. So I don't worry too much. I wouldn't worry too much about that for India, simply because when I remind myself of all the bilateral investment treaties that United Kingdom is involved in, and all the others, like Germany, I also looked at the facts for those and all the others. I don't think India, if it wishes, as I repeat, to fulfill its ambitions to become an economic powerhouse, which I think it's duty bound to pursue, I don't think it cannot, then I think it has to deal with this in the way that other countries have and said, as a quid pro quo, the domestic system will have to lose a certain amount of discretion in order to provide that element of confidence and security to the international business community. And in that way, India will benefit from the inward investment, which is what India really wishes to pursue, and also trading with the rest of the world. So I wouldn't be, I think that's not something that I would be overly concerned about if one reminds ourselves what the overriding objective of this is.
Mr. Sudi, I have a question for you, that in the Renu Sagar case, under there was the Foreign Award Act, which was subsequently repealed, in which the Honorable Supreme Court laid down few guidelines for the implementation of, for the enforceability of foreign award, and laid down the conditions and said that these three principles, which is fundamental policy of Indian law, interest of India, justice or morality, if these things are not covered under the award, either of it, the award is against the public policy, and yes, it can be set aside. And these three principles are till date followed in every case, and even in the latest judgment also, Honorable Supreme Court has followed it. Now, when we seek enforcement of award under ICSID, these three principles are absolutely ignored. No, there cannot be any PIL. There cannot be any kind of petition in the court seeking that that enforcement of that award should be stopped, because the regulations are such. So, from that perspective, what about the dominance of Indian judicial system to control the legislature for doing something against the public interest? Will that not be against the interest of the constitutional oath what we take, or not the roles which has been imposed on the judicial system to control the interest of the country? Sir, can you hear me? Sir, your voice is not there. Sir? Sir, you're mute. Sir, you're mute.
Am I audible?
Yes, sir. Thank you.
Is You see, out of the three principles which Renu Sagar laid down, the morality and interest of India are no longer there. As of today, as the law stands, the only issue is of public policy. And I said also that even the judiciary being a part of a sovereign country, and since it's a agreement between sovereign country to sovereign country, we'll have to, after creating the necessary ecosystem of legislation and all that, even that would come under this, that whether the right interference is taking place or not. But Supreme Court is very clear that in rarest of rare cases would it come in. And these cases would be that rare that even in the ICSID, I'm quite sure that they would lead to annulment rather than anything else. Therefore, the arbitration system now in India is very strong. But for ICSID to come in, India has to join, has to sign, and then to create appropriate legislative changes so that award can be implemented immediately now. I fully agree with Mr. Patel that if India has its economic ambitions as being an economic dynamo, then there is no way out. They have to do it. 183 countries have already joined here. You must also keep it in mind that India has an excellent track record of making payments. Even with white industries, they have paid the total amount. There is not a single international default for wherever the liability is there. If that is the attitude of India and that is how they are going to conduct, yes, we need to build a system where the businessman is totally assured, whosoever is investing, and it should be done if we really want to move fast. I fully agree with Mr. Patel and fully agree with Dr. Nadumpur on this.
Sir, the point is that in the present Indian judicial system, every Indian citizen has a liberty to raise his voice if he finds that say, there is something which is against the interest of the country. Now, if we have some international awards which may turn into a political game, from that perspective, it cannot be discussed in the Indian courts at all, because Indian courts will lose their jurisdiction to sit upon such awards. So, will that not be against the interest of the country?
As I said, that as the law stands today, neither morality nor interest of India is a consideration. It has been overruled. Now what will happen is that court will entertain it. Nobody can stop anybody from filing a petition, and court would say, sorry, we don't want to interfere. That is the pro adjudication arbitration awards. That's the mindset of the judiciary at this juncture. Take away some stray judges here and there, but by and large, that's the philosophy, and they're following it. They mean it.
So, in a way, Professor James,
Yeah.
so India needs to balance out a situation like UK, where we adopt unsettled as well as ICSID. What do you say on that? How can India do that balancing of these two by adopting these two regulations?
I agree with you. So before answering your question, I should also say that, the objective of all these bilateral investment treaties is basically to depoliticize the matter. So sometimes, once you get a very adverse award, like, the UCOS award concerning Russia, which amounted to around $50 billion, then no one should be able to open up the award again. I mean, of course, in certain rare situations, a court or tribunal can go into it and maybe set aside it or refuse to enforce it. But in a normal situation, these treaties actually try to depoliticize. So I agree with Mr. Patel also that the UK is actually the best model, but the UK has been an international arbitration hub for a long period of time, and there is actually a culture of arbitration in the case of the UK. And UK again being at the vanguard of international or transnational litigation, the UK can actually implement this kind of reforms much faster than we can. So India has definitely a major challenge at its hands. India has, as you rightly, you pointed out in the beginning, India has terminated nearly 70 treaties. So out of 86 treaties that India had signed, India terminated most of them. Some of them are going to expire. And India has only signed a few international investment treaties, the latest one being Brazil. So India has to actually travel a long way in terms of embracing international treaty arbitration. And the local community, the judges, the local bar, all will have to basically get acclimatized to the system. It is not an easy thing because we are not actually a hub of in arbitration. I mean, that is our aspiration so far, but the reality is that we are far away from it. So maybe what the government can do, we need to have certain policy flexibility, because in the case of India, given the the diversity that the country has, it is absolutely possible that these kind of instruments will come for very harsh criticism. If the government signs the ICSID, I'm sure there will be a lot of opposition to it. Some of them may be valid, some of them may not be that valid, but there will be criticism. But at the same time, it is extremely important for India to take a unified position in terms of protection to investment. So we terminated 73 treaties. Now we have got only 5 treaties. So going forward, the one question is that, are we going to sign the ICSID convention only to deal with the 5 treaties, and that too with very small countries? I think that cannot be the case. So India will have to, before taking a decision on ICSID, my humble view is that India should take a position with respect to investment treaties. Does India want to sign more ambitious, more substantive treaties than it has signed in the last 1 or 2 years? If it can take a very clear position in its approach to investment treaties, then signing ICSID will be the second important issue, because ICSID is only a platform for resolving a dispute. So there are major challenges. Of course, I think the white industries has completely disrupted the field, and we are unable to take a decision so far. So my feeling is that immediately in the next 1 or 2 years, India will have to take a very clear stance on in its approach to investment treaties, and then later whether India should join ICSID or not. But at the same time, we have to think and we have to study and examine the provisions, in what areas we can retain certain amount of policy flexibility. People in the negotiation will say everything is actually negotiable. Everything is negotiable. So, there is actually a provision in Article 54 of the ICSID Convention that says that the award should be subject to immediate implementation. But at the same time, the ancestral working group is actually one method of introducing transparency in investor-state dispute settlement. It is actually a mechanism for having a second tier of examination, in having an appeal body. So these are the areas where India will have to play a very important role if the ultimate objective is to sign the ICSID Convention. So we had to make the parallel efforts. We had to actually take a uniform policy with respect to investment treaty arbitration. We had to play a very important role with respect to the ancestral working group 3. We had to also take part in other international initiatives. In the World Trade Organization, there is again a parallel initiative on investment facilitation. So the purpose of that initiative is to make sure that the investor can make an investment through a single window clearance. There is actually a certainty on loss for some time. So there are multiple efforts in order to facilitate and promote and protect investment happening in different bodies. And my feeling is that the Department of Economic Affairs or the Government of India will have to take a very clear, cohesive position in this matter, and then take all the parallel steps, including supporting domestic arbitral institutions within the country. At this moment, we do not have a very reputed even commercial arbitral body within the country. We want to be a hub like Singapore, but that is still remaining aspiration. So that is why I think we have a lot of domestic homework to do before we aspire to become bigger.
Thank you very much, Mr. So, Mr. Patel, going ahead with this process, can you please put some light on the entire process of ICSID, since you have been appearing as a counsel for various international clients? So how does it work? Can you give us some idea about it? What are the practicalities? How the lawyers how the lawyers participate in? Is it like as good as any other process? What are the what is the venue for the ICSID arbitration, and how the regulations are implemented, and what is the easy process of this? Or
That's a very broad request, but in general terms,
yes,
if we had another 4 or 5 hours, then we
okay.
could go through the rules and so forth. But we all have to remind ourselves that the rules are very straightforward and very simple to apply and understand, and deliberately so, because we all remind ourselves this is arbitration. These are decisions by parties to not to litigate or go down the traditional route. And so it's not a daunting process to begin or initiate an ICSID arbitration. The procedures are very standardized and mimic UNCITRAL in large ways, the rules, for obvious reasons, because one wouldn't want to have different rules and procedures applying. So in my experience, it's very straightforward. It is fairly cost effective. There are still fees to be paid and so forth, but very, very convenient. And the process can be fairly swift, depending upon which rules and additional rules the parties adopt and do not adopt. I think that the question you asked, I think it should be dealt with for another webinar, really, if we wanted to.
We will have it.
Because you just asked me to explain this. But what I would emphasize, and I really want to pick up on this, because although I sit in London, I am of Indian origin, and I do come to India, and I do have involvement in India. And it is my aspiration for India to be an arbitration hub. And it has been my wish for many years for that. But for whatever reason, it's not arisen. But I do think now is the opportunity for India. One, because it has a highly competent legal profession. Two, and this is most important, it has an outstanding judiciary. Yes, you get the odd case, as been mentioned, where you have a judge who is judicially active for whatever reason. But in my reading of the more recent authorities on international arbitration, enforcement of New York Convention awards in India, they very much mirror the decisions which are being made in the United Kingdom, in New York, and all the other convention countries. And I do think now that I do see the phrase arbitration friendly being used in India in the way the judges started to use that in their judgments in the last few years. So it's a mindset which I think, and I do think the judges, the judiciary, are able to deal with these disputes, these international disputes. And so the only thing lacking then, as has been mentioned by the professor, is the equivalent of the London Arbitration Centre or the Singapore Arbitration Centre or Hong Kong. We remind ourselves those arbitration centres took many years to become popular and successful. I mean, Singapore took 15 years and they've spent a lot of money. But the one thing that I have from my experience is the reason why litigants or parties to an arbitration want to go to Singapore is because of the quality of the judicial system. Because if they go to the SIAC and they need some sort of interim remedy or whatever, they have the Singapore judiciary. And I believe that in India, it has the same opportunity. I really do, with all my experience with India. It's just a question of, professors mentioned political will. I don't know why India terminated its bit with the United Kingdom in 2017. I don't know why it terminated the bits with Germany, Italy, and so forth. But the professor makes a very good point. It's no purpose is achieved by simply becoming a party to ICSID without having these treaties. Because it's the business community who says, well, have you got these treaties? That's what they're looking for. So I think that India can and will find itself that it has to take these action, because otherwise, as Mr. Suri said, it will not be able to fulfill its economic aspirations, which it has a duty to fulfill, in my view, to its people, ultimately.
Thank you.
But as you asked me about my experiences,
we have another round of
I just want to stay on. It's not about me. I want to stay on the topic of India rather than my experiences as a practitioner.
It is really very relevant that with the views coming from the three panelists who are internationally known personalities and nationally as well, that ICSID is very important regulation and most wanted, you can say, from the business point of view, that India should be part of this entire process. And we hope that Government of India will definitely consider it. And Professor Jain is already on the job. Very soon we're going to have some good policy changes, I think. The time is up, sir. I know Mr. Suri has to leave for some arbitration as well. Thank you so much for joining us. I really thank all of you, and from the core of my heart and on behalf of the firm, to be part of this webinar and giving us a insightful discussion on the entire issue. Thank you so much, and definitely we will look forward of another round of such discussions on some international topic related to arbitration and commercial litigation. Thank you so much, sir, and I wish you all, a very wonderful time, and be safe. Thank you so much.
Thank you.
Thank you,
very much.
Mr. Patel and Mr. Nirampura.
Thank you.
Thank you, Mr.
It was
Suri.
my
Thank you,
pleasure.
Professor.
Yeah, right.
Thank you.
Thank you. Thank you.